Hello, ladies and gentlemen. Now we're going to go over Chapter 7. Of course, this is Criminal Law, CRJS312. And we're in the book, Contemporary Criminal Law. Second edition is where my outline is on, so that's what I'm kind of talking from because I created the outline a while back. I did cross-reference it with the newer versions of the book to make sure it was still relevant, and it is. But definitely read your textbook. And the fifth edition is the one that's technically required. But of course, I have no means of checking your textbooks if you have the textbook, because this is essentially teaching online. So you can get old. I guess if you can find the second edition, that would definitely help you. But either way it goes, you need to read, because my lecture is just a supplement of the reading. It's not the reading. So can't substitute. My lecture cannot substitute for you reading it for yourself. So it only helps. It supplements. So, okay, let's jump into this thing, man. Chapter 7. We're going to talk about attempt, conspiracy, and solicitation, or what we call the inchoate or beginning crimes. As an introduction, inchoate or beginning crimes provide that individuals can be convicted and punished for an intent to commit a crime when this intent is accompanied by a significant step towards the commission of the offense. But the offense doesn't actually have to be committed. There are three inchoate crimes. There's attempt. An attempt punishes an unsuccessful effort to commit a crime. Then there's conspiracy. Conspiracy punishes an agreement to commit a crime and an overt act in furtherance of this agreement. And then there is solicitation. Solicitation punishes an effort to persuade another individual to commit a crime. The conviction of an individual inchoate crime requires 1. A specific intent or purpose to accomplish a criminal offense, and 2. An act to carry out that purpose. So that's what all of them have in common. So individuals who commit inchoate offenses may be punished less severely than or as severely as they would have been punished if they had completed the crime that was subject to the attempt, conspiracy, or solicitation. So I'll say it again. Individuals who commit inchoate offenses may be punished less severely than or as severely as they would have been punished if they had completed the crime that was the object of the attempt, conspiracy, or solicitation. So let's start out with attempt. Attempt is an unsuccessful effort to commit a crime. In other words, it's a failed try. Complete attempt, what we call complete but imperfect. When an individual takes every act required to complete the crime and yet fails to succeed. So I'm going to murder someone. I aim the gun and I shoot and I miss and they get away. That's what we call a complete or an imperfect attempt. That means I took every step. I just have bad aim. I'm terrible. Then we have what they call incomplete attempt. That's when an individual abandons or is prevented from completing the crime due to the arrival of the police, or as a result of something else outside his or her control. So I'm going to kill the person, I'm pulling the gun out to shoot him, but as I do so, the cops come, so I'm like, can't do it. Or something else happens, and I can't do it. Then we have an impossible attempt. That's where the perpetrator makes a mistake, such as aiming and firing the gun only to realize that it's not loaded. It would have been impossible to complete the attempted crime intended, or the crime intended. History. Now, what's the history of attempt? Attempt was not originally recognized as a crime. Attempt was finally recognized in common law courts like Retz v. Schofield and Retz v. Higgins. When we say Retz, that means the crown. That means it comes from Great Britain. So that means the Crown versus Higgins, or the Crown versus Schofield. The intent may make an act innocent in and of itself criminal. all offenses of public nature, of a public nature, that is, all such acts or attempts as tend to prejudice the community are indictable. The public policy of attempt. First, there's retribution. An individual who shoots and misses or makes efforts to commit a murder is as morally blameworthy as a successful assailant. So in other words, you get what you deserve. You shouldn't have tried it. Then second, utility. The lesser punishment for attempt provides an incentive for individuals to halt before completing a crime in order to avoid being subjected to harsher punishment. Then three, we have incapacitation. The individual has demonstrated that he or she poses a threat to society. So of course we want to punish them for what they've done, and that may stop them or incapacitate them from doing it again. So what are the elements of attempt? First, we have an intent or purpose to commit a crime. That is the mens rea. An intent or purpose to commit a crime. Then you have an act or acts towards the commission of a crime, and that's two. And then three, you have a failure to commit the crime. So you have the intent to commit a crime. With that intent, you take actions in furtherance of commission of the crime, and then you fail to commit the crime. For whatever reason, whether something intervened and made it impossible, or made it, let me go to these attempts. Something intervened to make it incomplete, or it might have been a complete attempt. You just sucked at committing the crime and you failed, or something happened or intervened to make it incomplete, or something happened to make it impossible. So, attempt, and the book has the equation for it. A step towards the completion of a crime, coupled with a specific intent or purpose to commit the crime attempted, and then third, a failure to complete the crime. What is the mens rea of intent? Of attempt. I said intent. What is the mens rea of attempt? There is a dual intent crime. An individual must intentionally perform acts, so the acts you perform are intentional, that are proximate to the completion of a crime. And the individual must possess a specific intent or purpose to achieve the crime itself. So you're taking knowing or you're taking purposeful action coupled with a specific intent to achieve a crime. Now, there's a broad approach. When a defendant knows that death is likely to result from the destruction of the building, it is appropriate to hold him or her liable for attempted murder. So that's kind of a broad approach that says, well, whatever this person was planning to do or started trying to do, if it was completed, people would have died. So now we're going to say it's attempted murder. So that's kind of a broad brush. I would say it depends on how far you get. I would say it should be about how far a person gets towards the completion of the crime before you charge them with something that didn't happen or something that didn't result. Because some things a person attempts to do, the obvious result would be death, but you shouldn't hold them responsible for attempted murder unless they got enough significant steps done. If you aim the gun and you fire it, that's pretty close. You missed, but that's enough for it to be an attempted murder. But if you got the gun and you aimed it and you realize you didn't have no bullets, that may be an attempt, but something impossible happened, so you didn't really get close enough to the completion of it to now be held liable for attempted murder. So, got a case, Smallwood v. State. A Maryland Court of Appeals, a Maryland Court of Appeals was confronted with the issue of whether a rapist with HIV was guilty of attempted murder of victims. The court, of course, he was convicted, but the court reversed the defendant's convictions for attempted second-degree murder and assault with intent to murder because the defendant's exposure of his rape victims to risk that they might contact the HIV virus from him was insufficient for the trier of fact to infer an intent to kill. What now? We have the intent. What is now the act? The actus reus of attempt. Two steps in considering the actus reus of attempt. One, determine the legal test to be applied because they're differing approaches. And then two, apply the legal test to the facts. So there are two different legal approaches. First, there's the objective approach. Anytime I use the word objective, that means you're stepping outside of yourself and you're saying, what would a reasonable person do? Anytime I use the word subjective, you're putting you're acting as that individual. Like, what would I do if I was that person, given everything that that individual person is and has going on. So there's a difference. Objective is like a standard person, that standard fake person that doesn't exist. Subjective talks about an individual as a subject, being that individual, and what that person should have done because they're that person. So there's an objective approach, jurisdiction. It requires an act that comes extremely close to the commission of the crime. It distinguishes preparation or planning and purchasing of materials to commit a crime from acts taken to perpetrate the crime. So in other words, what is reasonably close to the commission of crime is all that counts for it to be an attempt. So like, different preparatory things, of course, if you're going to kill somebody, you got to do it with you might want to do it with a gun. So going to buy the gun, even though you're doing it with the purpose of killing someone, in an objective jurisdiction is not enough to be an attempted murder. You have to buy the gun, do other stuff, and then pretty much get dang close to trying to murder the person before it counts. So that's the objective approach. Then we have the subjective approach. It focuses on an individual's intent rather than his or her acts. It's based on the belief that society should intervene as soon as possible. As an individual who possesses the required intent takes an act towards the commission of a crime. The intent may be revealed by an individual's statements or actions. Critics of the subjective approach say the early intervention fails to provide the individuals with the opportunity to change their mind at an early stage and risk punishing individuals for bad thoughts who may never, in fact, actually engage in the bad acts. So in a subjective approach jurisdiction, me purchasing the gun with the intent to kill someone might be enough to charge me with attempted murder. It doesn't require that I get closer to the actual attempt before I can be held liable. So it intervenes pretty early. So you can see how that's kind of unfair because, in my opinion, because you want a person to get, if a person buys the gun, there's a lot of things that could happen up until they commit the act. So there's a lot of situations where they can change their mind. Let me see. So then, so you have those two views: the objective, subjective. Then you have one more. You have three legal tests, and this is modern. The physical proximity to the commission of the crime test. The defendant's acts come close to completing the crime. The focus is on the remaining steps required. So, what else did the person have left to do to have successfully committed the crime? Of course, if you fired a weapon and missed, you pretty much you did the last thing that had to be done for the other than actually hitting the target. You did the last thing that needed to be done for the crime to have actually been committed. You just failed. It's less demanding than the last step approach. Objective approach provides that an attempt occurs when an act is very near or dangerously close to the completion of a crime. An individual must possess the immediate ability to complete the crime. The act must amount to commencement of the consummation of the crime. Then you have unequivocal or clarity of purpose to commit a crime test. Without any other information, an ordinary person looking at the defendant's acts would conclude without a doubt that the defendant intends to commit the crime. Also known as what we call the re ipsa loquitur test, or the thing speaks for itself test. Whether an ordinary individual observing the defendant's acts would conclude that the defendant clearly and indisputably intends to commit a crime. The focus is on what an individual has already done, not what they have left to do, but what they've already done. The defendant's statements to the police or to other persons are not considered in this analysis. So, an example under this, the moment an arsonist arrives at the crime scene with the necessary materials, most would conclude that the defendant possesses a clear intent and is guilty of attempted arson without even trying to set the house on fire or getting close. Based upon the circumstances they're caught in, we're looking at what all they've done as opposed to what all they have left to do. And we're looking at them and we're catching them in that moment and saying, well, look like they're about to commit an arson, so it's now attempted arson. Then we have, last but not least, the model penal code or standard step to what we call the step towards commission of a crime. The defendant's acts are sufficient to clearly indicate that he or she possesses an intent to commit a crime. It simplifies matters by providing an understandable and easily applied test for attempt. To constitute an attempt, an act must be a clear step towards the commission of a crime. This step is not required to come close to the completion of the crime itself. The act doesn't have to be strongly corroborative of the actor's criminal purpose. The focus is on the acts already taken by the defendant towards the commission of the crime. An example would be lying in wait or searching for or following the victim, or enticing the victim to go to the place contemplated for the commission of the crime, surveillance of the site of the contemplated crime, unlawful entry of a building or vehicle that is the site for the contemplated crime, possession of materials specifically designed for the commission of the crime, and soliciting an individual to engage in conduct constituting a crime. It asks whether an individual has taken affirmative acts towards the completion of a crime that, in combination with other evidence, indicates a defendant possesses a criminal intent. So I know that's a lot, and we're talking about different jurisdictions. So all I want you to remember, basically, with attempt, is there is a intent to commit a crime first and foremost. Let's reverse it. There is a purposeful action taken with a specific intent to commit a crime, and then that crime is not committed. So that means the crime has failed. So we got all these these tests and all this stuff, all that really, and you got the physical proximity or substantial step test, which measures how far you got. And I'm not going to go into all that. The book talks about it, so you may get stuff on test about it, but let me talk about it a little bit, just because I think there are multiple choice questions. The substantial step test significantly broadens the authority of the police to arrest individuals for an attempt to commit a crime. In the case of People v. Rizzo, this is the application. So this is the application of physical proximity. So, physical proximity test versus substantial step test. The court rejected the notion that searching for a contemplated victim constituted contempt. The four men had not progressed beyond preparation, and their acts were not immediately near or dangerously close to the commission of the crime of robbery. The model penal code would have found that this was enough to constitute attempt as a substantial step. So with the model penal code, they talk about substantial step. So it's all about how far you've gone, as opposed to with physical proximity, it's about how instead of how many steps you've taken, it's more about how close you are. So it's two different things. So when we talk about physical proximity, we're talking about how close are you, how far or close away are you from committing the crime. When we talk about substantial steps, we say in other words, how many steps have you taken? So they're coming from two different angles. So if this is the start of the crime and this is the end of the crime, the substantial step test says how many steps did you take to get closer to committing the crime, right? With the physical proximity test, we say if this is the ending result of the crime, we say, well, how far is the end result from where they are? So you see, they're coming from two different directions. So I know it sounds a lot. It's weird. That's why it's weird in teaching it, because it sounds so crazy. A lot of this stuff is like, well, that's just saying it's like tomato, or half dozen versus saying a half dozen versus 6, right? So I don't want to mix you guys up. So I'd rather you just know the basic elements of attempt and keep it moving. So let's move on from attempt. So one of the best defenses to attempt is what we call impossibility. You have what we call factual impossibility, where a factual circumstance that prevents an individual from actually completing the offense. An extraneous factor, an event outside the individual's control. Factual impossibility is not a defense to an attempt to commit a crime. So what that means is you had every intention of committing the crime, but something else intervened. It wasn't you pulling away. It was something else happening, like the cops pulling up or something like that. Like, well, I was about to shoot you, but the cops came, so you leave. In other words, that's not really a renunciation of the attempt. So then you have what we call legal impossibility, when an individual mistakenly believes that he or she is acting legally. So you think what you're doing is legal, but it's not legal. So legal impossibility is recognized as a defense, where one possesses a criminal intent to violate a non-existent law. Then you have what we call inherent impossibility, when the situation in which a defendant could not possibly achieve the desired result. Like example would be sticking pins in a voodoo doll or something like that. So factual impossibility is never a defense, because you were trying. So like you had the gun, but you drew the gun and you clicked the trigger, but you realized it wasn't loaded. That is still enough of an attempt. So the factual impossibility is because there was no renunciation or something else that really kept you from committing the crime. You still wanted to do it. So that's not a defense. Of course, legal possibility is an inherent impossibility is when what you were trying to do essentially it wasn't possible anyway. Like pins in a voodoo doll. Let me see. Skip some of this stuff. The next defense is abandonment, when one backs out of the crime after taking steps towards the commission of a crime. It's only a defense to attempt when an individual freely and voluntarily undergoes a change of heart and abandons the criminal activity. So in other words, it can't be because there was some type of factual impossibility that kept you from committing the crime. It has to be because, you know what, I don't want to kill this guy anymore. I'm wrong. And you turn away. So like I said, so abandonment can be a defense, but factual impossibility is not. Not a defense where one abandons the crime based on the intervention of outside or extraneous factors. Reasons for recognizing the abandonment as a defense is, of course, there's no longer a purpose. There's a lack of purpose. And then 2, it's also an incentive to, for one to renounce a crime. If I knew I was going to be criminally liable, even if I didn't want to do it anymore, I might as well do it. So you kind of you don't give an incentive to step away from the crime. Now let's move on to conspiracy. The next inchoate crime. Conspiracy is an agreement between 2 or more persons to commit a criminal act. At common law, conspiracy was complete with the agreement to commit the crime by itself. In modern law, in some jurisdictions that don't apply common law, the agreement must be accompanied by an affirmative act, however slight, towards the carrying out of the conspiracy. So at common law, all you had to do is 3 people that said, let's rob a bank, and they planned it, and that's it. It's conspiracy right there without any steps being taken. At modern law, however, you sit at the table, you plan, and then something has to be done to a step has to be taken towards the commission of the crime. So it's the agreement plus a step taken in the commission of a crime. Conspiracy does not merge into the attempted or completed crime. So what's that mean? That means conspiracy is separate from the crime itself. So you can be charged with both conspiracy and the crime. So you can be charged with murder and conspiracy to commit murder. They don't merge into each other. So of course, with an attempt, if once you commit the crime, it's no longer an attempt anyway. The attempt goes away; it disappears. But with a conspiracy, there's you can be charged with both of them. It doesn't merge. So there's the agreement to commit the crime, and you're charged with the crime itself. Okay, the Pinkerton rule, and we talked about this in another chapter as well. An individual may be found guilty of all criminal acts committed by one of the conspirators in furtherance of the conspiracy, regardless of whether the individual aided or abetted or was even aware of the crime. So the example, and I always use this every semester, if anyone's ever seen that movie Heat, it's one of the best movies ever. Al Pacino and Robert De Niro in the movie, and they're opposite. They're acting opposite of each other. So one is the bad guy. The good guy is Al Pacino. He plays a detective in the homicide and major crimes unit, and in Los Angeles. I think it's based in Los Angeles. And then you have Robert De Niro, who plays the bad guy. He is a bank robber. He gets his team together. They plan bank robberies, and they commit these robberies, and they've been doing pretty good. In the movie, they were doing Robert De Niro and his crew were planning a job, but they needed one more person. There was somebody they needed, and they got this guy Wangro to do the job with them. And no one ever really liked Wangro. I forgot who brought him in, but their rule was, hey, no one gets hurt. We're going in. We got like 3 or 4 minutes, and we're out. But what happens is, I want to say Wangro killed someone, and based upon the Pinkerton rule, there's now a conspiracy to commit a bank robbery. So what happens is, once this other person who is a part of the bank robbery conspiracy commits a crime that's foreseeable, because of the inherently dangerous nature of bank robberies, shoots and kills someone, that now means everyone in the conspiracy to commit the bank robbery is now also a murderer. They've also conspired to commit murder, which changes things. That means you go from 10 to 15 years to actually life in prison, or you're going to be considered a murderer. Hold on. A murderer because of the acts of one of the people. So you see why they were peed off. And in that movie, they ended up getting Wangro. In general, conspiracy to commit a felony is a felony. A conspiracy to commit a misdemeanor is also a misdemeanor, but it's also punished usually a step below the crime itself. The actus reus. What are the criminal acts needed for conspiracy to take place? First, there has to be the entering into an agreement to commit a crime. This is normally proved through circumstances that strongly indicate that the defendants agreed to commit a crime. Then you have in other modern statutes, an overt act also must happen in furtherance of the crime. So at common law, it was just the agreement, but in modern law and modern jurisdictions, it's the agreement plus some act in furtherance of the agreement, an overt act. The overt act requirement is satisfied by even an insignificant act that is far removed from the commission of the crime itself. So if we say, hey, we plan to rob a bank, we just need some guns. Then the next day, our guy that agreed to get the guns goes to buy the guns. And then he gets caught buying illegal guns or whatever, and they found out it was going to be connected to a bank robbery. Now there's a conspiracy to commit the bank robbery, even though we didn't really get close to doing it, but we had the agreement, and then there was a significant step, no matter how close, to us committing the bank robbery. Okay, an overt act by any party to the conspiracy is attributed to every member and provides a sufficient basis for prosecuting all the participants. Like I said before, 5 or 6 people agree to rob a bank. We have one guy that's in charge of getting guns, and we all walk away. The rest of the other 4 go home and go to sleep. This guy goes to go get some illegal guns, gets caught. Now we're all conspiring, and they found out it's about a bank robbery. Now we're all conspirators of a bank robbery. Even though all that happened, even though only one guy went to do something in furtherance. So once you're in a conspiracy, you're locked in together, homie. So what that other person does in furtherance of the conspiracy can complete and make it now a conspiracy. What they do while we're in the conspiracy, killing someone or doing something, is now everybody's crime as well. This is intended to limit conspiracy prosecutions to agreements that have progressed beyond the stage of discussion and that therefore present a social danger. So now we got the actus reus. What's the mens rea? The mens rea of conspiracy is the intent to achieve the objective of the agreement. The model penal code requires a specific intent to further the object of the conspiracy. So there is an attempt to achieve the object of the agreement. And then in model penal code, it requires a more specified intent to further the object of the agreement. People v. Laria, a phone message operator was charged for conspiring to further a prostitution scheme. The conviction was overturned because the prosecution had to demonstrate that the defendant possessed an intent to further a criminal enterprise. There was insufficient evidence that the defendant took any direct action to further, encourage, or direct prosecution activities. Intent to further prosecution might have been established by evidence that he promoted and encouraged the prostitutes or received substantial financial benefits from the activities. But all he was an answer service. All he did was give messages. There was no evidence that he was actually acting with or in furtherance of the actual crime that was taking place. Now, parties to a conspiracy. It's what we call the plurality agreement. 2 or more persons, the plurality requirement. That means 2 or more persons must intentionally enter into an agreement. A conspiracy can't be with one person. It has to be 2 or more. They have to enter the agreement with the intent to achieve a crime. The bilateral, or what we call joint view. A charge of conspiracy against one conspirator will fail in the event that the other party to the conspiracy lacked the required intent. In a 2-person conspiracy, there are where one of the conspirators was an undercover cop or legally insane, lacking the ability to inform intent, the other conspirator would be acquitted. There must be at least 2 guilty conspirators or none at all. So that's the bilateral. I mean, bi means 2. So it means both people got to have the intent. Then you have the unilateral view, and this is the model penal code. It concerns whether a single individual agreed to enter into a conspiracy rather than focusing on whether 2 or more persons entered into an agreement. The fact that one party is an undercover police officer or lacks the capacity to enter into a conspiracy does not result in the acquittal of the other conspirator. The concern arises where officers could entrap assailants into a criminal agreement. The structure of conspiracies. And this is going to be the fun part. The structure of conspiracies helps to determine how liability will be distributed and whether some conspirators will even be liable for the activities of others. First, you have a chain conspiracy, and this is normally in narcotics distribution. Let's take Frank Lucas, for instance. I use Frank Lucas because he's, probably not you don't want to call these people the greatest, but I would say he's the most historical, greatest black drug dealer of all time because he had an ingenious plan. And in his plan, he actually cut a lot of cost. He pretty much had um, no transporting or pretty much no transport cost for getting opium or heroin from Asia and getting it brought into America directly to the East Coast. He had essentially no cost. He had to grease a couple wheels and make a couple people happy, give a couple dollars, but as far as the cost itself, he had none. So his conspiracy is an example of a chain conspiracy, and the reason I talk about him, and they say never celebrate criminals, but it's almost like we always talk about Al Capone. They even name places. This is the Al Capone suite in the hotel. He stayed here before. He was a criminal. He was just white. It's almost like black criminals. We can't celebrate them or talk about what they've done and glorify them. So we're going to talk about Frank Lucas tonight. So what he did, he was a heroin dealer. He started under Bumpy Johnson. When Bumpy died, he essentially assumed control of Bumpy's operation. Of course, he killed a few people to do it, but he did it. Then, upon assuming control of his operation, he figured out a way to essentially cut the middleman in the drug game. So, in the drug game, you have the of course, most drugs have to be manufactured from a supplier, right? Let's take heroin, for instance. Matter of fact, we'll talk about cocaine. And this is the crazy thing about cocaine. Cocaine, of course, is a part of a coca leaf. And same thing with heroin. Heroin is a part of the poppy plant. It's derived from the sap of the poppy plant. So it's only grown in certain regions. Asia and Southeast Asia. A lot of places there's some places that might have the climate. They can try to grow poppy, but it's not going to be good heroin. The best heroin comes from actually the Vietnam area, that Southeast Asia area, and Afghanistan is now, I think, the number one producer of opium and heroin. And of course, it's also produced for pharmaceutical companies as well. Where do you think they get these painkillers from? All those come out from the same family. But what happens is it's grown because it's a crop. It's actually a plant. And that shows you how a lot of time, especially during colonialization, a lot of things were perverted to access. And used in perverted ways, meaning that it's supposed to be for good, but it was turned into something else, like cocaine. For years, the Inca and the South American tribesmen and the people that inherited South America had walked past this the coca plant for years. They knew because, of course, the elders and the shamans knew that this plant can provide you energy. If you're ever tired, just take a leaf and bite it and chew on it and suck on it, and you'll be back. It's like a 5-hour energy. They knew that, but they never cropped it or did anything special to kind of pervert it to excess. They just used it. It was something. Oh, that's coca. Take this. Take this. Just chew on this leaf, and you'll be fine. So, and even I think it even like cured ailments and headaches and stuff. So they just did it. But then, of course, with colonialization, people don't realize when Europeans colonized places, they didn't just colonize the people and the land. They also colonized the horticulture and the agriculture of that place. So that means if these people now have this plant that is now this mysterious kind of drug that helps gives me energy, and it solves and it essentially it makes me better, and it solves my headaches and solves my minor ailments. As if I'm colonizing, I want to know what that's about. So that kind of creates a situation where they find a way to figure out what is in this coca plant that is essentially making it what it is and giving you this energy. So of course, through chemical processes, they synthesize and take out and synthesize the cocaine chemical from the plant itself. So people don't realize when we talk about cocaine, it's not so the coca leaf is grown, but when it's grown, it has to be picked. The leaves have to be picked, and then a lot of chemicals have to be poured into it. A lot of things have to be mixed. Has to be cleaned and purified. So it's and it's not pure. When they say purified, it just means that the cocaine is synthesized better and the better quality. It doesn't mean the chemicals used are pure. You're talking about using stuff like gasoline, kerosene, ether, all this stuff to synthesize and draw cocaine out of this plant. That's why when people use cocaine, it's like you know what they use to make that. But it's done at a farming level, and of course now it's become this drug that people go to jail for and people are addicted to. But I say all that to say, there is a manufacturing cost. There's a cost to the farmer. Now, the thing about cocaine is these farmers are regular farmers. They farm other stuff, and they're usually subsistence farmers in South America, and they're very poor. They grow and they process the original cocaine. They send it off so it can be repurified and kind of stepped on again. And when I say stepped on, it means broken up and kind of spread out to where you use maybe a little bit of cocaine mixed with other stuff to weaken it, and it makes it look like a lot of cocaine when it's really a little bit of cocaine mixed with other stuff. So that helps them sell it. And of course, because it comes out 100% pure, if you what they call step on it one time, maybe use half a kilo of cocaine and mix it with half a kilo of additives, there's still going to be some pretty good cocaine or strong cocaine. But they do that because now they can sell what is only half a kilo of cocaine mixed with half a kilo of other stuff to make what is presumably a kilo of cocaine and sell it for the price of a kilo of cocaine. They've now, you split it in half, and now you've made the money for 2 kilos of cocaine off of 1 kilo of cocaine. So it's basic economics. So imagine doing that. Imagine cutting that kilo into fourths or even eighths and doing the same thing. You now multiply your money. But that's what the middleman does. So it comes from the farmers. The farmers make pennies on the dollar for producing it and going through that. And plus, it's illegal to have cocaine crops. So they're doing this and they're farming this stuff in the middle of the South American jungles while the cops are flying over helicopters looking for them. So they have all these initial risks. But these drug lords who now end up being the middleman, they only give them pennies on the dollar for taking that initial risk, and then the middleman ends up distributing it everywhere. So the way a chain conspiracy goes, the drug is produced or manufactured. Then once it's manufactured, it has to go to a distributor, which is kind of a middleman whose job it is to take it and then give it to everyone else. What Frank Lucas did with heroin is he was able to, because normally because these drugs aren't produced in America, so by the time it gets to America, it's a very poor quality because it's come all the way from Asia. It's hit like maybe 10 people, 10 in the chain of custody, 10 people who have now broken it down and stepped on it themselves and now sell it for even, to get even more profit off of it. So what Frank Lucas, so that makes what actually gets on the street is heroin, but it's like weaker heroin. It's like, okay, it's not something that people are writing home about, and the addicts aren't. They like it because all they got, but they're not like, wow, this is the greatest heroin I ever had. So what happens is Frank Lucas gets a connect in Vietnam, because this is happening during the late 60s and early 70s, so the Vietnam War is in full effect. So we have Americans on Vietnam soil. The story says that he had a friend or a cousin who was in supply chain management for the Army, so he was over there, and his job in the Army was transporting stuff. So not only that, that guy was able to get Frank Lucas connected directly to the opium field, a guy that owned an opium, like literally he cropped opium. He had a crop and he farmed it. And so Frank was getting heroin straight from the source, and it hadn't been stepped on, hadn't been cut or anything. It was just heroin. Literally straight from the plant, processed, and it's right there, straight out of the sap of the poppy plant. And now he's getting it in almost infinite amounts. So this cousin says, you know what? There's not going to be any transportation cost, because guess what else was coming home from America? From Vietnam to America almost daily: the dead bodies of American soldiers. So pretty much they had an ingenious plan to get America, the American military, by if you put the drugs in the lining of so they weren't in coffins yet, but like the carriers for the bodies, it could go undetected, and the American government is literally going to they ship these people back to the morgue, the morgue, which is in Delaware. They ship these people there, where they're embalmed and processed, and they get their military honors, and they're shipped out to their families. Their remains are shipped out. But once it gets to Delaware, the one thing they do in processing dead soldiers is they're usually wrapped in linens, and there's a linen process where they got to clean this stuff, process it, send it back. So Frank Lucas, they devised a plan where they set up these shell businesses, or a situation where we have a linen cleaning company that's going to come pick up the linens. But what do you think they were picking up outside of linens? They were getting the drugs, and once the bodies were taken out, they were then getting the drugs out of these containers. So literally, they had no transportation cost. The drugs came straight from the field, and America essentially brought it over here for them. The American government was sending it, and they had no idea. So then it gets here, and it's not stepped on. This is 100% pure heroin, and it hits the street, and is the best quality heroin. As a matter of fact, it's so good, it killed people. It killed some people. So people were like, wow, where's this powerful drug, and who is producing it? And he even put a brand name on it. It was called Blue Magic. So at this point, because he has no cost, it's pretty much all profit. He pays the guy he gets the heroin from an upfront cost. He has no expenses getting it here. So really, it's all sale. Once he pays for it, he gets it. It's all money. He's making money off of it. Yeah, and matter of fact, that he becomes the distributor himself, because now everyone else, because of his product, now they want his heroin too. So he ends up selling to the mafia, the mob, and other underworld, underground people of different other cultures. Everyone who wanted to be a part of the heroin game. He had his own supply and his own brand that he was putting out, and he was supplying them with this pure product. So that was how that conspiracy worked, and that's what we call a chain conspiracy. The reason it's a chain conspiracy is a chain is only as strong as its weakest link. So you have links in the chain. If one of the links is broken, then that ends the conspiracy. So you got to have the guy in the field that's farming it. You got to have the supplier. You got to have that is a supplier. You got to have distribution. Then from distribution, you got to have processing. Then from processing, you got to have the guys on the street corners. So you got all these steps, and all these are necessary links. If one is gone, if you don't have the supplier in the field, you don't have no heroin ever makes it to the street. If you don't have the distribution, then no heroin. It may make it to America, but who's giving it to you? You know what I mean? So that's what you call a chain conspiracy. The conspirators at one end of the chain knew that the unlawful business would not and could not stop with their activities, and those at the other end knew that if it had not begun with their actions. So the corner boys know that, hey, I'm selling this heroin on the corner, but it came from somewhere. We got to get it from here, and we're waiting for more product. And they were selling like hotcakes. He got caught eventually, to tell the full story, because he kind of made himself a liability because he was kind of flashy. So in his early life, he kind of lived an unassuming life. wore a regular business suit every day, wasn't real flashy. So people just thought he was a businessman because he owned legitimate businesses. Now he was kind of washing his money through these businesses. Brought his whole family up from Greensboro. He's actually from right here in Greensboro. And brought his cousins and nephews up and had them in different businesses in the 5 boroughs of New York. So literally, he's a supplier of New York without any cost, and he has all these, I think auto shops, funeral homes, stuff like all these cash-heavy businesses that you can easily start and run cash through. So he's doing that. So he's running these businesses. So he's kind of unassuming. People look at him like, oh, he used to be Bumpy Johnson's driver. So no one pays him any attention. They didn't think it was him. Neither did the cops, right? So then later on, the story has it that he was at the first Ali Frazier fight, and he was sitting front row in Madison, front row in Madison Square Garden. And the crazy thing about that is that's where cops go to figure out who's who. If you want to know who the celebrities are, not just the celebrities, but who the drug dealers are, who the pushers are, who the high rollers are, you go to these big events and you see who's sitting where. Us regular folks and even the corner boys usually aren't sitting courtside at a Knicks game or aren't sitting ringside at a fight. But Frank Lucas was, and not only was he sitting there, he had on a full-length chinchilla coat, and with a matching chinchilla hat. So he had on a crazy fur. That fur probably cost, $20,000, but he was wearing it. And they had his wife. He was married to a former Miss Puerto Rico. So he had this fine woman on him, and she was decked out. And the cops were like, who is that? So then they find out, and they start investigating him, and they find out. Of course, they're in his run, and that's what ends the conspiracy. So that is a chain conspiracy. That's the Frank Lucas story. A wheel conspiracy is a conspiracy. If you imagine a circle, a tire, or a wheel, and you have a spoke in the middle, one thing in the middle, and in the middle, that is the crime. That is the completed crime. And then you have all these spokes connecting the wheel itself to, I guess, what do you call it? To the axle or whatever. So you need these spokes, but these spokes never touch each other. So you have different parts of a conspiracy. This happens and this happens, but there's not a chain. They're not connected to each other. So you can have 100 people in a conspiracy. Now, you usually got one guy that's leading it that has all these different people doing different things, but each person is not connected to each other, and some of them don't even know each other exist or are a part of it. So with that, it's like, okay, the conspiracy is broken up, but then when some people are taken out of the conspiracy, it doesn't stop the other people from doing what they were doing in furtherance of the conspiracy. So that's a wheel conspiracy. It involves a single person or group that serves as a hub, which is the middle, the hub of the tire. You got the wheel around it, and you got the spokes, which is a hub or common core connecting various independent individuals, or what we call spokes. So the spokes typically only interact with the hub rather than each other, so they don't know about each other. In the event that the spokes share a common purpose to succeed, there is a single conspiracy. In those instances in which each spoke is unconcerned with the success of the other spokes, there are multiple conspiracies. So, criminal objectives, agreements to commit crimes, the Wharton Rule, an agreement by two persons to commit a crime that requires the voluntary and cooperative action of two persons cannot constitute a conspiracy. So if the crime itself calls for two people to commit it, then that crime can't also be charged with conspiracy to commit that crime. Like we talk about adultery, adultery in certain places. So there's essentially two people having sex. It requires two people. So they can't also be charged with conspiracy. You also have prostitution as well. So where prostitution, of course, it takes two to tango. So you can't be charged with prostitution and conspiracy to commit prostitution. The only time prostitution can be a conspiracy is when there's a third party involved, like a pimp or something else that's kind of making the transaction happen. Then it can be a conspiracy. But if it's just two people in the hotel room trying to hump and a person exchanges money, then that's not a conspiracy. That's just prostitution. It doesn't become a conspiracy to commit unless there's an outside person or a third person involved to make the transaction happen. So that's the Wharton rule. The Gahardi rule: an individual who is in the class of persons that are excluded from criminal liability under a statute may not be charged with conspiracy to violate the same law. Where a defendant was charged with transporting a minor child across state lines, the minor child cannot be charged as a conspirator in that event because they were the class. That person was in the class of people to be protected by the law, by that individual law. Conspiracy prosecutions are favorable because there's no requirement for an explicit agreement, only a commitment to a common goal. Multiple prosecutions for both conspiracy and actual crime and other reasons. So let's hurry up. The conspiracy, the equation, an agreement or agreement, and is an agreement, and that agreement in certain jurisdictions and modern jurisdictions must be paired with an overt act in furtherance of the agreement, plus the specific intent or purpose to commit the crime. So the actus reus is the agreement, and in modern jurisdictions, the agreement plus an act taken in furtherance of committing the crime, and the mens rea is done with a specific intent or purpose to commit a crime. So the initial intent or the general intent of conspiracy is the intent to enter into an agreement, the purposeful entering into an agreement, and then there's a specific intent at the end, and that's the purpose, for the purpose to actually commit the crime. So now we're going to finish up with solicitation, our last inchoate crime. Solicitation is commanding, hiring, or encouraging another person to commit a crime. This generally results in punishment slightly less severe or equivalent to the punishment that is usual for the crime solicited. The example is the greedy spouse hiring a contract killer to kill his wife. If murdered, both the spouse and the killer are guilty of homicide. If unsuccessful, both the spouse and the killer are guilty of attempted murder. An agreement between the spouse and the killer with an overt act is a conspiracy. If the killer refuses, the spouse is still guilty of solicitation. So you see that in that one fact hypothetical, we had different, differences in, different changes to facts, but it's one hypothetical. But you see how with one thing changing, it could be one crime and not the other, right? So of course, if the killer, if the person hires a contract killer, at the point they hire that person and they do it and they try to get the person to commit a crime, they're now guilty of solicitation. The public policy behind it is, of course, you don't want people doing that. You don't want people essentially trying to get people to commit crimes. Social danger. An individual who is sufficiently motivated to enlist efforts of a skilled professional poses a continuing social danger. Then you also want to intervene. Solicitation permits the police to intervene before the crime is fully implemented. States typically protect individuals against wrongful convictions by requiring corroboration or additional evidence to support the charge of solicitation. The crime of solicitation. It involves a written or spoken statement in which an individual intentionally advises, requests, counsels, commands, hires, encourages, or incites another person to commit a crime with the purpose that the other person commit the crime. So once again, this is kind of a specific intent crime. That means there's a purposeful or an intentional communication with another person that asks them or tries to get them to commit a crime, and it's done with the intent that that person actually commit the crime. So it's kind of a double mens rea there. It's the intentional act coupled with the specific intent that you're trying to, it's in furtherance of getting that person to commit the act. The mens rea of solicitation requires specific intent or purpose that another individual commit a crime. You are not liable for a comment that is intended as a joke or uttered out of momentary frustration. Like, oh, I wish somebody would kill him. He get on my nerves. That's not enough. It has to be something like, hey, I'll give you $10,000, real talk, if you kill that person. That's something that could be not conspiracy, but a solicitation. That's the mens rea. So it just requires an intent or purpose that another person commit a crime. What is the act? The act of solicitation requires an effort to get another person to commit a crime. So you communicate to him, you make him an offer. Hey, I got some money. I'll pay you if you do it. That is all you need. Solicitation occurs the moment an individual urges, asks, or encourages another to commit a crime with the requisite intent. The criminal act requested need not be completed. 3 points. The crime is complete the moment the request is made. There is no requirement for an additional step such as a payment or a phone call. There must be an effort to get another person to commit the crime. It may be direct or indirect, may constitute the use of suggestive or seductive remarks or materials, or even, trying to pass money. In the model penal code, an individual is guilty of solicitation even in instances in which the letter asking others to commit the crime is intercepted by authorities before reaching a requested party. So in other words, it's almost like just the attempt or try, you send the letter or you send, and I don't know why someone would put it on paper to commit I want you to kill somebody, I'm going to write it down. Will you kill him for me? I'll give you $10,000. Why would you write it down? But if someone does that, let's say that letter is intercepted by law enforcement. The model penal code says that person is still guilty for solicitation because they essentially sent out by sending it out via mail or sending it out via courier, they had already committed the solicitation. Even if the person they were sending it to never got it, just the essentially putting it out there was all that needed to be done. That's the model penal code. So solicitation, the equation, it equals intent or purpose for another to commit a crime, coupled with words, written statements, actions, inviting, requesting, or urging another to commit a crime. That's what solicitation is. So we're not going to go into the cases. That is Chapter 7. So once again, your reading is important, and using the book's website, let it focus, www.sagepub.com, /Lippman, CCL2e. Once you get to that site, go to the student resources. You can go chapter by chapter, look at the outlines for the chapter, and do the quizzes. I suggest that you do the quiz questions. Those are important because I use them again. I promise you. So be good, you guys.